Morning.
Are we on? Are we up and running?
No sound.
Okay.
The trouble along there. Kiss.
Yeah.
10 minutes, 9 minutes. Make sure the sound works. You get the recorder. Just hit that. Hit the red button.
Okay.
Go. Okay, and then we'll figure it out. Turn it off.
Okay.
Washers, $8,000 just for bolts. Bolts and washers. That's a lot of money.
Where are you gonna get those?
I got one on. They want a fancy steel for the square head, so that because you're gonna see them in the trusses. And the architects, let's do that. I'll get them cheaper. It's more expensive than mine.
So what do I have to do when we get started here? Is just,
I'll take care of it.
what time is it? Well, okay.
What's out on there? It's the crystal that you go.
Okay.
Lock the door so you can close it.
Okay. Yeah, because it's hot enough in here now.
I turn the heat down.
Yeah, good. 'Cause it's plenty warm.
do anything simple and quick. Then turn the sound off.
No, I think everyone's here. Is that correct? It's a little before 9, but why wait if we can just get started? Is that
It looks like we have everybody we need, Mr. Hearing Examiner.
right? So is it all right if we just get going here? It's a little before 9, but why not, right?
No opposition.
Great. Okay, Ms. Tejas, are we ready? You gave me the thumbs up, so it's fine. All right, well, we're back on the record. This is day 2 of the hearing in case number 19-00200 UT. My name is Christopher Ryan. I'm the hearing examiner in this matter. We came very close to finishing this proceeding yesterday, but questioning of staff's witness, Mr. Jack Sidler, was likely going to take more time than all parties had in after hours. So we're back for day 2. We left off, staff had presented all of its exhibits, I believe, and was ready to pass the witness. Is that right, Mr. Bogacco?
That's correct. I think we have all our exhibits in through Mr. Sidler, and Mr. Sidler is still under oath, as I understand things, and I believe he is ready to be passed to the next questioning party.
And we'll just swear him in again, just for completeness. So Ms. Tejas, if you could just swear the witness, just so we have that on the record.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
All right, so I believe it would be complainant's opportunity to ask Mr. Sidler any questions for cross-examination. Ms. Berg. She's muted. There, I believe you're unmuted now.
Can you hear me?
Yes.
You can hear me now? Okay.
Yes.
So my questions for Mr. Sidler, Mr. Sidler, on February 26th of 21, in your prepared direct testimony, I noticed in the Appendix A, it says, did you see my name or my husband's name attached to any of the conflict you listed in Appendix A on pages 1, 2, or 3?
My case list in Appendix A?
Yes.
No, because I don't add the cases to my case list until after they're completed.
Have you ever seen my name or my husband's name on any of your case lists in the past?
No, I have not.
Did you see P&M's name attached to conflict 14 times on page 1, 6 times on page 2, and 4 times on page 3?
Mr. Hearing Examiner, may I ask for a clarification on that question? I wasn't clear on what Ms. Berg is asking for.
Yeah, I think basically, Ms. Berg, what you're asking Mr. Sidler to identify if he's appeared in cases involving PNM. Is that what you're asking?
Let me just ask this question. Does the fact that PNM's name is attached to conflict 24 times in your Appendix A listing give you any concern that there is an unfortunate pattern of conduct that is ongoing?
Objection to the question in terms of the use of the word conflict. I'm not exactly sure of the context of that question. If the complainant would rephrase the question for clarity, that might be acceptable, but
I believe, yeah, and I understand your objection, Mr. Bagacco. I believe, Ms. Berg, if I understand correctly, you're asking Mr. Sidler whether or not he has a conflict of interest given the fact that he's participated in cases involving PNM.
No,
No?
Mr. Hearing Examiner, I am just trying to point out to the fact that my husband and I had never heard of the PRC until my neighbor pointed that out, and our names have never participated in this kind of ongoing conflict for a terrible amount of time.
all right.
Sure. So Ms. Berg, okay, let me ask another question. Are you asking Mr. Sidler whether or not his involvement in cases involving PNM indicate that therefore PNM is engaged in bad practices?
No, I'm just trying to bring to attention that I believe that my husband and we are not engaged in an ongoing pattern of unfortunate conduct that leads to a gross misuse and abuse of time and resources and power and authority.
Yeah, so I'm gonna preclude you from asking Mr. Sidler that question because the reference that you're making right there is actually a response to Mr. Bogacco's arguments in the motion in opposition to your motion to recuse. You know what you wrote in that motion, Mr. Sidler in no way, shape, or form is responsible to respond or incompetent to respond to anything there. So you may ask Mr. Sidler other questions, Ms. Berg, but that question I'm not going to allow you to ask. Do you have any other questions for Mr. Sidler, Ms. Berg?
Is it possible for Mr. Sidler to understand how someone who looks at your Appendix A could be led to believe that there is a gross misuse and abuse of power, authority, time, and resources when PNM's name appears 24 times on those 3 pages?
PNM will object to this question at this point. It really misunderstands the nature of the cases that Mr. Sidler has listed in his appendix, and Ms. Berg's characterization of them is incorrect.
Sustained. And now how about this, Mr. Sidler, for the benefit of the complainant, she's trying to ask a question about your job, Mr. Sidler, and I think inferring things in light of the fact that PNM's name appears in cases you participated in. Can you tell Ms. Berg a little bit about what your appendix case list is and why PNM's name appears there? And can you clarify for Ms. Berg that not all of those cases in any way, shape, or form indicate that PNM has in any of those matters necessarily engaged in wrongdoing? Mr. Sidler, if you could.
I didn't say wrongdoing, Mr. Hearing Examiner.
It's the inference. Let Ms. Berg, thank you. Mr. Sidler, can you speak a little bit to what I just said?
Well, in the workings of the commission, various electric companies file cases like to increase rates, to build power plants, to build transmission lines, things that are needed because of the regulatory construct. In New Mexico, they have to get our permission to do certain things. And as an engineer in the PRC, I worked on all those cases along with other people.
Thank you.
The company name in my Appendix A is only the company that filed the case.
So, Ms. Berg, for your edification, for instance, the top of the list there is 07289, abandonment of a 46 kilovolt line. That's not a customer complaint. That's not in any way reflective that P&M did anything relating to anything that's involved in this case. They simply wanted to abandon a power line because presumably it was no longer useful, or they were going to do a new one. Who knows? I don't know anything about that case. But there's no way to read this appendix as reflecting that P&M has engaged in any type of conduct at all that's going on in this case, according to you, based on this case list.
And I agree with that, and I thank you. I agree with your statement there. I just have heard you, Mr. Hearing Examiner, express concern about the financial cost of this particular case. And when a person like me looks at Appendix A, I see an enormous amount of time and resources just in those 3 pages alone. And so I just want the commission to recognize that it has never, ever been my intention to engage in a gross misuse and abuse of time and resources.
That's a legal argument, Ms. Berg, and thank you. That's not testimony, actually. The question, and I'll clarify for the record, the hearing examiner has never commented upon what costs are incurred here in a manner that suggests that this is a waste of time or resources. That is an inference Ms. Berg has drawn and the complainants have drawn from whatever they believe can supply that. Whether your claims ultimately have any merit, Ms. Berg, is an ultimate determination to be made after briefing by the parties in light of the evidence fully submitted at this hearing. And we are here now to speak to Mr. Sidler, who will now provide us additional information about whether your claims in this case have any merit. So,
hearing examiner.
Can I move on to my next question?
Yes, let's ask Mr. Begacco to say something.
Mr. Hearing Examiner, in the interest of efficiency and getting this proceeding to move along, and given the special circumstances we're faced with, is there any way I can just get running objections pertaining to the issuance of compound questions that assume facts that are not in evidence, and then questions that are really attempts to inject additional testimony into the case? Is that something the hearing examiner would find acceptable, so that maybe I don't have to constantly interrupt Ms. Berg?
Yes, Mr. Begacco, that's correct. Ms. Berg, I acknowledge Mr. Begacco's, your questions have to be questions. You don't have an attorney. The complainants in these pro se matters are entitled to come to these proceedings to ask questions and to feel satisfied that they've been provided due process under law, but you have to ask questions, and we can't have you testifying through questions. So if you have actual questions for Mr. Sidler, you are free to ask them. But I think Mr. Begacco's broader point is we need to just move along and finish this whole proceeding. So what question do you have next for Mr. Sidler, Ms. Berg?
My next question is about, Jack, would you agree that informed consent touches our lives every day in countless ways? For example, if you— I'm
not going to allow you to ask that question, Ms. Berg. It's predicated on a faulty understanding of what informed consent is. It's irrelevant to this proceeding. I have written about this extensively. You have a statement right now that you're not going to be able to ask that question. If you find that objectionable, you can appeal that determination to the commission or to the, well, you can't appeal to the commission, but you can appeal to the New Mexico Supreme Court on that question. Ask your next question, Ms. Berg.
Jack, did you see all of the documents, P&M documents that I sent to the PRC showing residential on each application or form, in spite of the fact that was a clear designation on all of those forms I sent in with P&M's name on it? Residential was clearly indicated on those documents. But in spite of that, we were.
Ms. Berg, you're testifying and you have to ask a question. Questions are relatively simple things. Just ask a question. Don't testify.
Jack, did you see all of the P&M documents I sent in showing residential on each application? But in spite of that clear designation, we were put in a commercial rate class without our knowledge and consent.
Mr. Harris,
Yes. Mr. Bogacco, go ahead.
same group of objections, but I would also request that if the complainants would like to address filings with Mr. Sidler, that they would do him the courtesy of pointing him to specific instances in the record, including page and line number, so that Mr. Sidler can at least have the benefit of knowing precisely what they are talking about. And again, my prior objections still stand. I'm hearing a compound question. I'm hearing a question that is attempting to assume facts and evidence, and it also seems to be touching on another attempt to inject additional testimony into this case. So if we can keep it clean for the benefit of the record, and in the interest of me being able to protect my client from unfair questions, I would very much appreciate it.
I agree with everything Mr. Bogacco just said. The question I will construe that Ms. Berg asks is, Mr. Sidler, did you see all the pleadings that complainants filed in this case?
I looked at all the proceedings, everything that was filed in this case over the last 2 years. Do I remember all of them? Not necessarily.
Okay, Ms. Berg, ask your next question.
If the New Mexico law 7.6.2.10 NMAC states that a home-based food vendor cannot sell to grocery stores, any restaurants, retail stores, internet outlets of any kind, that you can still claim that my baking is a commercial operation when it is no such thing?
Yeah, I understand, Ms. Berg. It's a leading question, which is, on cross-examination acceptable. I'm going to rephrase the question in light of Mr. Bogacco's objection to say, do you have any doubts, Mr. Sidler, about your or P&M's conclusion that this is that the studio is correctly billed at rate 2A?
I believe that the studio is correctly billed based primarily on the building type of the structure.
And then Ms. Berg's next question was something about, is there anything within the city of Santa Fe? What she pointed to the regulation and asked, do you have any doubts about the applicability of 2A based on your understanding of the regulation to the studio?
Familiar with the regulation.
Okay, then you can answer that. That's the answer to your question, Ms. Berg.
Mr. Hearing Examiner, will I have an opportunity to ask you a question before this is over today?
You don't get to question the presiding officer in a proceeding.
Do I have the right, after 2 years and 8 months of standing up for what I believe to be ethics violations and a gross misuse and abuse of power and authority and time and resources, have I earned the right to ask you a question before this is over today?
You've earned the right to make arguments. In a society such as ours that has courts and tribunals that are there to litigate the complaints of individuals, you have the right to appear before them, present evidence, and make arguments to them. You do not have the right, on the other hand, to come to places that are legally, legitimate tribunals and say, I shall question all of this. That's not part of how this works. So very broadly, the answer to your question is, if you wish to make arguments, you of course are free to do so. It is my job to process those claims and to evaluate the law and your facts as presented in this proceeding. And you have every ability to do that, and will be provided that opportunity as law allows you.
So I didn't understand anything you said, but will I be able to ask you a question about what I believe is valid concerning this case.
You have the right to make arguments. I'm not here to be questioned. I don't have any facts to offer in this case. That's not what I do. You're the litigant, I'm the adjudicator, and I'm going to move on now. Do you have any other questions for Mr. Sidler, Ms. Berg?
Well, I was going to ask him, yes, I have one last question. Thank you. Mr. Sidler, do you recall the New Mexico Public Regulation Commission requiring or requesting that P&M put together a code of conduct back in the year somewhere around 2017? And if this requirement from the Public Regulation Commission was presented by the Utilities Division for P&M to put together a code of conduct which they called "Do the Right Thing."
Ms. Berg, you're testifying.
And why?
Okay. What was the last question? I didn't understand the question when I got Mr. Sidler.
Did PRC do that and why?
Objection. I'm just going to have to throw it out there. It's a compound question. And again, if there's a document to direct Mr. Sidler's attention to, that would be appreciated. Outside of that, if Mr. Sidler has personal knowledge of the thing that the complainant is talking about, then I would guess he could hazard an attempt to answer that question, but I'd very much dearly like for the compound question to be broken up so that Mr. Sidler can give discrete and full answers to the best of his ability.
Did you understand the question, Mr. Sidler?
Not fully.
Right. So, Ms. Berg, what Mr. Begacco said is that you have the right to ask the question, but you have to ask the question in a way that the witness is going to understand.
Okay, I'll try to shorten it. I apologize. Mr. Sidler, did the Public Regulation Commission Utilities Division request that P&M put together a code of conduct? And if that
Stop. That's the question. Mr. Sidler, if you can answer that question, answer that question.
Not to my knowledge. I'm not familiar with anything like that.
Ms. Berg, now continue to ask whatever the following question that comes after that question may or may not be.
The code of conduct that was required by the Public Regulation Commission for P&M to put together was called "Do the Right Thing." Do you recall that document and why was it requested?
I don't recall it.
Mr. Begacco, wait. Go ahead.
Same objection, and that one again is assuming facts, not in evidence. I mean, there are two questions in there, and if she can break up the questions appropriately and take it step by step. So among other things, we have a clear record, and then Mr. Sidler is not on the hook for answering a question that assumes something to be true that may not in fact be true. That's my objection. I know I was supposed to have running objections, but I'm here to check my client as well and to sort of, try to make this as clear as possible. I apologize for my interruption, but if those issues can be clarified, please do so.
So the initial question you asked, Ms. Berg, is he aware of a document? To which Mr. Sidler responded, no, I'm not aware of this document. I believe your next question was, okay, this document is called that, and this document has a title, and do you know something about it? And the appropriate answer there would be, well, asked and answered, because if he's not familiar with the document, I don't understand what further you can gain from asking about a document about which he's not aware. So unless you have some additional question that you think Mr. Sidler can answer, and it's predicated upon something that he has seen, just don't see where the rest of this is going.
Mr. Hearing Examiner,
Yeah.
if I may, maybe this will help. I mean, we do things a little bit differently at the commission. We have pre-filed testimony, and in this case, there are 5 items that consist of responses to bench requests, and then Mr. Sidler's pre-filed testimony, which ordinarily in the course of how we do things are the subject of any cross-examination in our proceedings. And so if the complainant has any questions stemming from those 5 documents, we'd be more than happy to entertain questions about those items. Failing that, though, I think, among other things, we are repeatedly treading outside of the legitimate scope of this cross-examination. So,
okay, yeah, no, I understand your point, Mr. Bogacco. That's a good argument. So, Ms. Berg, what Mr. Bogacco just said is the orders in this case, for purposes of questioning a witness on cross-examination, are limited to those matters of which the witness spoke about during direct testimony. I mean, I think on some level you're extended some latitude to inquire about, well, you didn't reference a document that maybe you should know about, and therefore, you didn't put it in evidence, and how can I then ask about it? But I don't even know that I would accept that what you've asked sort of goes in that direction, because you're trying to ask him a question about a document that he's never seen. So you know the answer to that question. So let's do this, Ms. Berg. Do you have another question, or was that the last one?
I have no more questions.
Okay. TNM, do you have any questions for Mr. Sidler?
Yes, Mr. Hearing Examiner, just a few. Good morning, Mr. Sidler. How are you?
I'm doing fine. Thank you.
Good. Did you attend the hearing all day yesterday?
Yes, I did.
And so you heard the testimony and cross-examination of the complainants, Mr. Oshigure and Ms. Berg?
Yes, I did.
And do you understand that one of the complainants' concerns in this case is that they allege that P&M failed to assist them in selecting the most economical rate class?
I remember that, yes.
And yesterday, I was trying to remember, I think it was in my questioning of Ms. Berg, but it might have been in my questioning of Mr. Jarrett, and I apologize. I shared Commission Rule 410.25A. That is one of the customer assistance rules of the Commission. Do you recall when I shared that rule on the screen?
I recall that, yes.
And that rule states that the utility shall assist the residential customer or prospective residential customer in selecting an appropriate rate tariff and furnish such additional information concerning that tariff as the residential customer may reasonably request. Is that your I mean, I'm reading the rule, but I could share it again, but would you?
I remember that.
Okay. Based on your understanding of the facts in this case, do you believe that P&M violated that rule with relation to the complainants?
objection, just for purposes of, calls for a legal conclusion, but in his capacity as an electrical engineer, I believe it would be appropriate for him to answer that, provided that we understand that Mr. Sidler is not an attorney.
Yeah, and so Mr. Sidler, what you can answer, I think, is there a factual predicate for a violation of this rule in some ways, regardless of how you understand it as a matter of law? I mean, I know that sounds strange, but do you see the basis for a factual predicate for a violation?
I don't see any basis for a violation of that rule, but I cannot testify to whether there was ever any assistance requested. I do not know that answer.
Okay. Okay. Well, and one of the reasons I asked that question, and I realize, yes, you're not an attorney and you can't, give a legal interpretation of the rules. But as Mr. Bogacco explained, I'm more concerned about the application of the facts in this case to the rules, and that does seem within the purview of the utility division staff, correct?
In what way?
To analyze and assess whether utilities that are under the commission's jurisdiction are in compliance with commission rules?
Yes, we do. We do try to determine compliance with rules.
Okay. And in your testimony, this is the direct testimony, February 26, 2021. At page 5, line 6, you're asked, should P&M be fined for its conduct here? And your answer was no. Has anything that you'd heard yesterday in this case or this morning caused you to change your opinion, change your answer to that question?
No, it hasn't.
Okay. Let's see. Sorry. You, in an earlier question from Ms. Berg, you noted that it's staff's opinion that the service to their garage and well is properly at a rate 2A. Is that right?
That's correct.
And do you understand the history of the first meter in this case on the complainant's property, that it was first meant to provide electric service for their well?
That's my understanding.
We heard yesterday that they actually, and I don't know that we all were aware of this, but we heard yesterday that they actually used the service after the well was drilled to supply their fifth wheel, correct?
Correct.
But based on the fact that the complainants first obtained electric service to serve a well, is it your opinion that rate class 2A was correct at the very beginning of P&M's provision of electric service to complainants?
At the very beginning, when it was just the well, I believe it was correct at 2A.
Okay. Okay. That's all the questions I have. Thank you so much.
Very good. Thank you, Ms. Padilla. All right, so Mr. Sidler, could you just tell me a little bit about your background so that I have some understanding about your nature of your education and familiarity with electrical systems generally?
Okay. Basically, I've been with the commission as an electrical engineer for the last 13 and a half years. Basically, started at the end of 2007.
And prior to coming to the commission, it's my understanding that you were in the electrical field. Is that correct?
Yes, that's correct. I'm both a licensed engineer as well as a licensed electrician.
Have you worked on people's houses, doing the sort of work that's sort of at issue in this case, is setting up meters, doing installations for new service, this kind of thing?
Occasionally.
Okay, so this is
most of my background as an electrician was commercial work like Intel, hospitals, Albuquerque Studios, Los Alamos Labs.
Okay, well, but you've had experience working with customers, and you've been in the, I don't know, provision of electrical services more generally, even in the resident or in a business capacity in the course of your life.
Yes, for approximately, let's see, I started basically working as a design engineer in '92, and then I got my electrician's license and started switching off between engineering and electrician's work.
Okay. So we heard extensively yesterday from Ms. Berg and Mr. Sugaray that Don's Electric was utilized to do much of this work. And the complainants testified, I'm sure you heard this, that they had either no conversations at all with Don's Electric about setting up the metering bases and the equipment for all of this, had no conversations with Don's Electric, or forgot they had those conversations. The question I'm going to ask you, and I'm just refreshing memory, and that's what I heard yesterday's testimony to be. Do you agree? Have I characterized their testimony correctly?
I believe so.
As a person who's worked as an electrical professional, even outside the Public Regulation Commission, is it plausible that Don's Electric did this work on their property without ever notifying them that they were going, that Don's Electric was going to do that work?
It's possible.
Is it plausible?
Yeah, it's plausible. Not all contractors have the same levels of communications with customers.
Okay. So you think it is possible that Don's Electric set up the 2 metering bases, had communications with P&M, and made choices for complainants without ever notifying them that he or whoever the person at Don Electric, I guess there's a Don, I don't know, I'm assuming that someone at Don's Electric did all of that without ever telling them.
It's plausible and possible.
Okay. I want to go to an exhibit. I'll just show it to you. I'm sure you've seen it. I'm going to share it on my screen. This is Staff Exhibit 19. And let me just pull up my Zoom controls here and share. Where are you? Share screen. Share screen 2. Are you looking at the Dell Electric bill?
Yes.
Or the proposal, excuse me. And this was admitted yesterday as Staff Exhibit 19. This is the complainant's response to the discovery request. And this relates specifically to the questions staff asked about, an estimate. And I'd asked questions about this too, during the course of these proceedings. Wait, how much was the estimate to get this work to combine the meters? Well, I want to draw your attention to that place there on the first box. You see my cursor hovering over.
Yes.
So it says that they're going to replace an existing 200 amp and 100 amp electrical services with one 300 amp electrical service. You see that there?
Mm-hmm.
So what I want to ask you, Mr. Sidler, I'm going to pull up another document. Let's see if I can just bring it up on my screen if it shares it. Not that one. Oh, no, there's a better picture of this. I was going to ask you if you could just describe for me on the metering basis, if you're able to make any judgment about, what is it, Staff 12? So I'm pulling up Staff Exhibit 12 now. And are you seeing the 2 metering bases and the meters?
Yes, I am.
I don't know why it's not loading. It's weird. Is it like only half showing? Do you see that?
Yes.
I don't know why that's happening. Let me stop share and see if it changes. I'll open it again.
Mr. Hearing Examiner, if it's at all helpful to you, I can try to open it for you.
Yeah, it is strange it's not opening. Let me close it and reopen it and see if it solves that. Just want to see the full picture. Oh, that's better. So I don't know, something in Adobe, it didn't like that. So let's go back to screen 2. You're looking at the full picture of those meters and the metering bases and everything, right?
Yes.
So, is the bigger of these 2 things the 200 amp? Two is bigger than 1, so therefore metering base for the 200 should be bigger than the 100. That's a very gross generalization. Am I saying something correct, or can we say anything about these?
Not necessarily. It could be the difference between number of circuit breakers inside the panel.
Okay.
It's really tough to, it's really tough to say.
Where are you?
Sorry, Ms. Berg, you're making some sounds in the background. Are you not hearing?
I thought I lost you all. I'm sorry, because there was so much silence. I didn't know what happened.
Okay. So you can't say which of these is the 100 and which is the 200?
Well, the one on the right feeds the studio.
Okay.
It would be the commercial service, so that would most likely be the 200 amp.
Okay.
Left is the residential, according to the diagram that Positive Solar placed on the back of these panels.
Okay. And I believe that, sorry.
And the residential service would most likely be the 100 amp.
Okay.
But as to why one's bigger than the other, that's really not necessarily easy to say without actually seeing the insides of the panels.
Okay. But I think I heard you correctly. You just said that the one on the right is for the studio and well. And if I'm not mistaken, that means that it must be, I guess that means it must be the 200 amp supply is the one on the right.
That would be my belief.
Right. That's what I thought too. Yesterday, we heard Mr. Sugaray say something to the effect of this Dell Electric person. I'm going to leave this sharing thing up just because it's useful to, I don't know, it's useful to me to look at it while we're talking. That the Dell Electric folks indicated to him that, you know, you would need 300 amps of power to provide the required load to the structures that the complainants initially intended, which was main house, guest house, studio, well. And I guess I'm wondering, is it possible that Don's Electric understood this? And I'm asking you to speculate. I have no doubt about that, because we're asked to try to figure something out what happened 15 years ago, part of the problem of this case. But what I want to ask you is it possible that Don's Electric installed the 200 amp service for the well, and based on what the complainants intended, knew that you'd need an additional 100 amp service, and therefore elected to put the second metering base in, use the 100 amp for the house, with the anticipation eventually you're going to end up with 300 amps worth of need? Do you understand my question? I'm trying to understand how this happened exactly, and maybe what Don's Electric was thinking when they set this up.
Well, the 100 amp service to the guest house is the minimum service required for houses.
Okay.
Code. At this point, I mean, it used to be there wasn't a requirement, then it was 30, then it was 60, and I believe currently it's 100. It's been a long time since I've really done that kind of design work.
Okay.
But the last I was aware, a house required 100 amp service. Now, that doesn't necessarily mean that there's 100 amps used in the house.
Okay.
That's just what, you know, what's required to serve a house.
Well, could they, I mean, here's what I don't understand is, like, the 200 amp was there serving the well, and then why wasn't the, I mean, I understand it was a 2A rate, and then they built a guest house. And so it seems like at some moment in time, someone says, oh, well, now we've got this guest house, we need to get power to it. And then rather than running it off the existing meter, they put a new meter in. And why do you think that happened? If you can venture any guess, and I'm very aware, I'm asking you to guess.
I cannot guess what was in Don's Electric's mind or the complainant's minds at the time.
Yeah.
You know, there could be various possibilities.
Okay.
I mean, for tax purposes, if you were going to do something in one building that you weren't going to do in the other, you might want to write it off on taxes. If it's a separate meter, you can write it off 100%. If it's not a meter, you have to prorate. And
okay.
there's other things it's possible that, you know, that's possible. One, you know, that if the guest house was served first with the 100 amp, it's possible that anything, you know, in that studio would not fit on that 100 amp service, and they had to put another service in.
Okay.
That's really something that was up to Don's Electric and the complainants.
Yeah, and I guess that's one thing you're definitely saying. What's not possible is that these equipment installations in any way, shape, or form reflect choices made by P&M. That's not possible.
They would not have been chosen. That would have not have been the choice of P&M. That would have been the choice of the complainant, customer, and their electrical engineer or electrical contractor.
So
P&M will hook up whatever they put in.
Right.
Passes inspections.
So I get response to to complainant's allegations that, oh, we have 2 meters, and what is that all about? The answer to that objection is, you selected this.
Yes, either the complainant selected it or the electrical contractor selected it, and it was never changed by the complainants.
Okay. So I want to just talk real quickly about you were asked to stand in here or adopt David Alt's testimony, and let me just pull that up. Well, I don't know that I need to pull it up, but I want to point out that, well, why don't I just do that real quickly? I think it'll be easier if you just all look at it. I'm going to share that on screen. This is staff's exhibit number 2, and that, sorry, I'm just looking for the, got so many windows open on my screen. Share screen, screen 2. Okay, so David Alt, he wrote this. I just want to note this for the record. P&M did something similar yesterday with some of its documents. It talked about, the factual presentation of information wasn't entirely accurate on one of their documents, and it has to do with the sequence of the development of complainant's property. And I noticed that Mr. Alt made a sort of similar error in some of this. So Mr. Alt says at the beginning here, as identified by Ms. Berg, complainants, she requested that service be supplied to her property in October of 2002. Well, we know that to be correct. And we heard yesterday, you agree with me, Mr. Sidler?
Yes, I do.
Yeah, so we heard that. I'm just gonna scroll down further. On July 16th, 2003, this is the middle of that page there, P&M began to provide service to a second building on the complainant's property that contained a kitchen and a well. Well, we know that's incorrect now, don't we, Mr. Sidler? Partially incorrect, let me put it that way.
I'm not sure that I understand what you consider incorrect.
So when she says on July 16th, P&M began to provide a service to a second building, that's true, on the complainant's property. And we know that second building was actually the guest house. It contained a kitchen and a well. I thought Mr. Alt here might be referring to the studio. That actually comes third, is my understanding of the facts. And of course, the well pre-existed and was the first thing served with power on complainant's property. Do you agree that that's the facts we have here?
Well, as far as the order of the buildings, I'm not really sure what building was built first.
Okay, that's fine.
Well, I know the well was put in first.
Right.
But as far as the order of the guest house versus the studio, I'm not sure that I really remember which came first.
And all I'm really doing here by asking you to clarify this, Mr. Sidler, is to acknowledge for the record, I mean, your point to say right now, hey, you're not entirely clear on the exact sequence of it all. I actually think that's quite fair. And I want to point out also for the record that as this document's being written by Mr. Alt in September of 2019, much of the facts we now know about this case weren't entirely clear. And the exact sequence of the order of the construction of the complainant's property really wasn't known until we got into this litigation. And frankly, even for myself, until I actually issued a bunch of bench requests, I didn't know what the facts were. So I know that's not actually a question, but I do want to note for the record that to the extent to which there are any misstatements of fact in Mr. Alt's testimony, which you, Mr. Sidler, are adopting, the hearing examiner is aware that there is perhaps some factual inconsistencies, but does not see that in any way to take away from the credibility of this document. So moving on. You proposed a resolution to this case at one point in time, and I just want to go over that with you, Mr. Sidler, because I want to understand it. You wrote, I'm just going to find that information.
Mr. Hearing Examiner, are you thinking of Staff Exhibit 3?
I am. And I'm just trying to find that portion where he says, this is my proposed resolution, and you have to replace some lugs. And do you remember that, Mr. Sidler?
Yes, that wasn't Staff Exhibit 3, I don't believe.
Discuss documents. On Staff Exhibit 3, beginning at page 2, it starts with that said staff observes a potential path forward. This is where Mr. Sidler was essentially discussing the path forward in a little more detail than previously iterated, if that's of any help. Otherwise,
Okay, I see that.
I see, and I'll bring it up real quickly. I found it as well. Thank you, Mr. Bagacco, for helping me out finding that. It's tricky keeping track of all these documents. So we'll just pull it up on screen. All right, so there, you're probably seeing now, and you wrote here, that said, staff observes a potential path forward that conceivably could be acceptable to both P&M and complainants without violating rates or any applicable regulatory principles. The issue could be possibly resolved by removing the second meter and serving all structures together as a residential complex from one metering point. P&M's only equipment in this area are the service laterals between the transformer and the top lugs in both existing meter bases and the meters themselves. So what I'm doing here by asking you this is I want to bring up again that picture of the meter base, and then I'll share that. And can you just describe for me what it is? What are the lugs? Like, what are those things that you just described and that need to be replaced?
Okay, the lugs in the meter, you can't see them in this picture because they are enclosed in the boxes.
Okay.
But behind the meter, there's a set of 4 lugs, 2 on the top, 2 on the bottom. Basically, just copper contacts. And then there's basically a piece of copper that sticks out on the back of the meter that slides into that lug to make the electrical contact.
Okay.
Basically like a wall. I mean, it's basically like a wall plug.
Okay.
Except they're bigger. And P&M's responsibility in this case is the meters themselves, P&M owns and maintains and services and all of that. But from the transformer, which is not in this picture, there's a wire that comes up underground and would go up into the conduit on the very left, looking at the 100 amp.
Is it the big one, the big steel one on the far left?
Yeah, the big steel one on the far left. And it'd be the same on the other panel.
Okay.
So their wires come up, go to the top and loop around and connect to those lugs on the top of that meter.
I see. And is that how the glass meter thing is kind of keeping track of how much energy is going through?
Yes, that's the meter that measures the energy. And so that their wire will connect to those top lugs. That's the end of P&M's responsibility for the wires.
Okay. And then on the right-hand side, the wires going out then, is that where the power then goes to wires that then branch out to complainants?
Well, the wire will come out the bottom 2 lugs of the meter. And then it'll loop around and into most likely a main disconnect at the top of this other side of the box.
Okay.
I mean, I believe that this is a meter panel board combination. Like you have a panel board in your house.
Oh, yes, I do. Right.
It has a bunch of circuit breakers, and there's one big one, usually at the top or the bottom. That's the main one. It'll shut everything off.
Okay.
So that will be most likely at the top. It could be at the bottom, but most likely at the top. And then there will be a bunch of circuit breakers underneath it.
Okay.
That serve the various loads off of that panel. And everything from the bottom of that through belongs to the customer, including the enclosures themselves.
Okay.
Boxes, the conduits, the strut support, all belong to the customer.
Okay. That meter base that's there, is it big? Is that a big, pretty sizable meter base, or is that standard? I don't really know.
Oh, I guess that'd be pretty standard for a residential.
Okay.
They come in all sizes. I mean, I used to install those things that were 4 feet wide by 6 feet high.
Okay.
But, for a light duty application like this, that's an average size.
Okay. That's good. I appreciate it, Mr. Sidler. It's a lot of information. Mr. Bagacco very helpfully went through with Mr. Jarrett some very basic points about how service points function and how it all works. So that was very useful to me. Okay. So, I was reviewing your testimony, Mr. Sidler, and what I found quite interesting actually is really your position from very early in this case to now hasn't changed. Is that correct?
No, it hasn't.
You recommended very early on in this proceeding that complainants have 2 meters. They're being billed the correct rate. If they want to change over to 1 meter, they can do so, but that's at their cost. And I guess the last question I have for you in that sort of sequence of thinking is, what is your position on complainant's entitlement to have the entire complex served at residential 1A?
If those 2 meter bases are connected to operate on 1 meter, and there's several ways to do it. They got an estimate from Dell Electric that would basically replace both of those boxes with a 300 amp box and a meter to accommodate it. And that's one way to do it. Another way that they could do it would be to just somehow reconfigure the boxes that are there so that 1 meter provided the power to both boxes.
Okay. Well, and those are the technical ways that they could have 1 meter. But then my next question to you is it your position that the complainants can have their residential complex, the electricity provided to the entire complex, all buildings, all improvements at the residential rate 1A?
It is, as long as they combine everything into 1 meter.
So I guess what I want to know from your perspective, Mr. Sidler, is as the staff witness in this case, do you perceive anything inconsistent in P&M's positions on complainants' entitlement to rate class 1A? And I'm going to preface that by just simply saying, if you read the documents in this case, I think what you'll see is they're saying, no, the studio is correctly billed at 2A, but you guys can have 1A if you want to get this all together. And I just want to know from your perspective, does that strike you as inconsistent, or do you have yourself, you satisfied that that's nothing is wrong about them taking?
Well, as it currently is, the 2 buildings are 2 distinctly separate buildings. They're served by 2 distinctly separate services by having two meters.
Okay.
And that's why, I mean, the way it's set up right now, 1A to the house and 1A to the studio.
2A to the studio.
2A to the studio, I apologize, is the correct setup, because the studio does not qualify as a house.
And I presume you also take the position then that the well is what? What is the well? What is the significance of the well to your understanding of the applicability of rate 1A or 2A?
Well, a well that's connected by itself would be considered a commercial structure because you can't live in it. I mean, the code lists the code in all the electrical codes from 1999 to present, and maybe even before 99, list the definition of a dwelling unit. That includes a kitchen, includes a permanent kitchen, permanent living quarters, permanent sleeping space, and a permanent restroom. And the studio has no permanent restroom, has no restroom at all. It has the kitchen, it has space that could conceivably be used for living and sleeping, but it does not have a restroom.
So let me ask you this question, and part of my job here is to try to anticipate what the commissioners are going to ask at the end of this proceeding when there is a recommended decision and the facts of this case are presented. And I just want you to respond as a fact matter, not as a legal argumentation. But imagine the commissioner says something like, well, wait a minute, this is obviously a residential complex. Obviously, this well was designed to serve a person's house. How can P&M argue that this is a 2A commercial space? And in any way, just respond to that concern if it were to be argued by a commissioner. What would you say?
There's nothing that I'm aware of that precludes a commercial structure being placed on a property alongside a house.
Okay, and I suppose that answer, you're just sort of embedded in that is this no, and I'll get to this moment in a second, is that there is some form of commercial presence on this property. Is that your position?
Well, there's a building on the property that does not conform to the legal definition of a residential structure.
Okay.
And the code is a legal definition.
I understand. And so that actually brings me directly to my next question, which is, yesterday, the staff presented a picture of a business license. And I think I want to just bring that up because when I saw that, I was actually, which picture? Here it is, it's 14. Are we looking at staff exhibit 14 or did I take the share down?
It looks like you took the share down, Mr. Hearing Examiner.
Yeah, let me bring that up. Exhibit 2. Now, I will say for my part, Mr. Sidler, and I don't feel compelled to keep my cards close to my chest or show them. I don't really think that's important to do. I will tell you that I'm familiar with all of the arguments from complainants in this case that there is no commercial kitchen, that in no shape or form is there any form of commercial entity on this property. I saw that business license and I was astonished, frankly. Can you tell me your experience of finding this and what you thought when you saw it?
Well, I mean, that business license looks like a business license that you see in any commercial establishment. I don't see anything on that business license that listed as being a home-based business.
Did you?
I'd be wrong. I'm certainly not a business license type person.
Sure.
But I don't see anything on there that says that business license is a business license for a home-based business.
The more specific question I want to ask you is, to the extent to which you were aware that complainants were suggesting that there was no commercial operation in any building on this property, did you reach any conclusions about that claim when you saw this document?
No, but my decisions and my testimonies and my answers to the bench request were all basically predicated on the structure types.
Okay.
I mean, I didn't really pay that much attention to commercial use versus non-commercial use, and that's more of a legal issue than it is an engineering one.
Okay.
But my basic evaluation was of the building types and the fact that they are totally separate. The second building is totally separate electrically from the house. It's physically totally separate from the house. It's not connected to the house in any way, shape, or form. And it's totally separate electrically by having the 2 meters.
Did you hear Mr. Jarrett's? Well, I think, and maybe he didn't testify to this fact yesterday. I'll stop the share the business license. I believe Mr. Jarrett's testimony in one of the responses to the bench requests in this case is residential complexes can in fact be all built under a residential 1A rate. Do you challenge that assertion of fact?
No, if they connect the electrical services, then it's all one service point. See, the other option for wiring that setup would have been to build the guest house, put a meter and panel in the guest house, take a line from the panel in the house out to the second structure, and take a line from the house to the well. And at that point, everything would be billed as a residential service because the meter was attached to was a residence and everything was electrically continuous.
That's interesting. So your point is that the actual rate classification will in some ways be contingent upon the way individuals choose to wire a series of structures.
Yes, I mean, if for instance, say you decide to build a garage out in your backyard, if you take, that's totally separate. If you take a line from the panel in your house, and actually my parents' barn is wired this way. They took a line from their house out to the barn. Well, it's all served under 1 meter and it's attached to a residence. So it's all residential. If you chose to put a second meter on the barn for whatever reason you chose to do so, that second meter would be commercial rate because that garage or barn doesn't qualify as a living structure, as a residential structure.
And so I guess what you would suggest is, so since the well was originally a 2A entity, the fact that they draw power from that route is itself significant in your mind?
Because they don't, I mean, I don't understand what you were asking.
Okay.
Well,
in this instance, in this case, the fact is that the first thing that comes in is the well. That gets built at the commercial rate 1A, or excuse me, 2A. And PNM's argument is all it is a well. And you've said this as well. A well is not a residential structure. A well in and of itself, just alone. And then PNM's other fact argument is, well, look, oftentimes people draw power to do construction from a well source because, you need water on the property initially, right? And so therefore, if subcontractors are drawing power to build structures, so that's a commercial use of energy. So that was an appropriate 2A. And then what comes next is the guest house, and that gets a separate meter. And then they finally draw power off the 2A commercial rate to power the studio. And if I understood your testimony correctly just a moment ago, you're suggesting that that's a significant choice on the behalf of complainants to draw power from the 2A commercial source.
Well, the complainants are perfectly free to move the well service to the residential meter.
Okay.
That's their equipment. If they want the well on residential service versus commercial, they're more than welcome to disconnect it out of that commercial service panel and move it over to the residential panel. At which point it would be served as a residential service.
Okay.
I mean, like I said, that gets back. They could have built the house, put the service in, served the well in the second structure from the house, and that's all one service. And it's connected to a legitimate residential building. So it's residential rate.
Yesterday, Mr. Sidler, you heard complainants, and I don't know if you're the person necessarily to ask this question to, but I'll just ask it and you can offer whatever opinion you have on the subject. You heard the complainants talk about not having knowledge of the fact they were being billed commercial rates because they don't read their bill. I realize, Mr. Sidler, you're an electrician and not a consumer advocate or a person who has expertise on how one should conduct themselves in the course of a lifetime. And I'm aware of this, but I guess from the commission staff's perspective, what do you make of complainants' position that they never knew about this commercial rate because they never read their bills in 15 years?
Well, it's their responsibility to read their bills. I mean, they can choose to read the bill, or they can choose to look at the amount due and just pay it. I mean, nobody has any control over that other than the complainants.
Okay, that's all my questions for Mr. Sidler. If there's redirect, we can begin with Ms. Berg. Please be aware, Ms. Berg, of all the discussion we had previously. Mr. Bogacco is continuing the objections. So Ms. Berg, if you have any questions on behalf of complainant for redirect, that is questions arising from the questions I just asked Mr. Sidler or any of the other cross-examination you heard, you may ask those questions.
Thank you. Mr. Hearing Examiner, you put up David Alt's testimony that Jack has adopted. And thank you for doing that, because I agree that there were misstatements on that document, the one that you pointed to on July 16th, 2003, PNM began to provide service to a second building on the complainant's property that contained a kitchen and well, and that is in fact false.
Yes, Ms. Berg, I understand, but you're not permitted to testify now, Ms. Berg. This is not an opportunity for you to testify. You heard what I said. If you agree with me, you don't need to point that out. you're given an opportunity now to ask Mr. Sidler questions based on the redirect. So feel free to ask a question.
Mr. Sidler, why is there 3 false statements on page 2 of David Alt's document on the final paragraph that says, upon the complainant's request, a second account was opened to serve the second building, which is false. And then it says in the next sentence, P&M has billed this second account under rate 2A or its equivalent since the service began, and that is false. And then the final false statement is complainants have 2 electric service accounts and 2 P&M meters because they developed their property to receive service in 2 separate locations, which is also false. Why are those 3 false statements there?
So, Miss, I will say right now, before I get an objection from someone, that actually you're making assertions, in fact, that aren't entirely true, Ms. Berg. They're sort of more nuanced than that. The hearing examiner is aware of the potential problems in some of the statements. I think the question to Mr. Sidler has to be something to the effect of, is in any way, Mr. Sidler, do you find Mr. Alt's testimony lacking in factual accuracy?
Well, Mr. Sidler, there is also an inaccuracy on page 3 that was not presented. And so why is that there?
Objection.
Yes, I agree. The question that you're asked, Mr. Sidler, that I'm going to allow Ms. Berg to ask you is, are you aware of any factual inaccuracies of Mr. Alt's testimony?
There appeared to be factual inaccuracies in this testimony of Mr. Alt.
And why wasn't that corrected in writing for all of us to see?
Because it was filed before, it was filed in this case before some of those inaccuracies came to light.
And Mr. Harris,
Ms. Berg-Echo was trying to, Ms. Berg, stop.
Excuse me, can we take about a 5-minute break?
Yeah, no, I think that would be useful. Is that okay, Mr. Berg-Echo? What were you going to say, and then we'll take the break?
well, that's fine. We can take our break.
Yes, and I appreciate, Mr. Sidler, that we all have needs to take breaks, and it's appropriate. Thank you.
Thank you.
Okay, let's return. Mr. Bagacco, you were speaking when we left.
Yes, Mr. Hearing Examiner. First of all, in terms of the line of questioning about the acknowledged and also alleged inaccuracies contained in Mr. Alt's testimony, which has been adopted by Mr. Sidler, I'd point out, number one, I believe those questions have been asked and answered. But number two, as you remarked earlier, Mr. Sidler has, in his own testimony, been consistent in his recommendations and his analysis throughout this case, including his 2 responses to the bench requests and the pre-filed testimony that was filed on February 26th. In view of that, I propose a way to, I guess, address any lingering issues or concerns about Mr. Alt's testimony to the extent that it is inaccurate or inconsistent. And that would be that to the extent that Mr. Alt's testimony is inaccurate or inconsistent, I think it should be viewed and understood that Mr. Sidler's 3 pieces that he's submitted in this case, I take it and I would subsume and supersede Mr. Alt's testimony. So Mr. Sidler's recommendations are Mr. Sidler's recommendations, and since he is now the lone witness in this case and the sole representative of the utility division staff, I consider his recommendations to be controlling. And if that's acceptable to Mr. Hearing Examiner, if he can crystallize that into a ruling or at least acknowledge it for purposes of the efficiencies in this case, I think that would be a good way to go. However, it's up to you, Mr. Hearing Examiner.
Yeah, my position on all of this, and specifically addressing any questions Ms. Berg might wish to ask, is that Mr. Alt was responding at a period of time when this case came in, and if you try to deduce from the informal complaint file all of the facts, you're not going to be able to do that. So it does not surprise me at all that there's subtle inaccuracies. It's a complicated matter. The real sequence of events wasn't known until much later in these proceedings. Mr. Alt is not making false statements. He's simply making what he believes to be the truth based on the information provided. So, Ms. Berg, to the extent to which your question is going to go along that line, I mean, that's, as the fact finder here, I can tell you there's probably nothing you can tell me that's going to suggest impropriety on the staff's point from Mr. Alt's inaccuracies to the extent to which any existed as documents. I'm aware of them, and you know my reasons as to why I think they exist. I've just said them 2 or 3 times now. So, Ms. Berg, do you have other questions for Mr. Sidler? She muted? Yes.
Yes.
Ms. Berg, you're muted. I'm sorry, Ms. Taya, did you have to say something?
Did you want me to unmute for some reason? I got a message to unmute.
No, I didn't. Maybe someone asked Ms. Berg to unmute.
Can you hear me?
We can.
I apologize. And I apologize if you interpreted the false statements that they could easily, as you said, be inaccuracies. And I highlighted many of them on David Alt's document, done with that subject. If I may ask Mr. Sidler, when you were talking about the meters, it is my belief that the first meter that was placed on our property is a 100 amp meter that services the well. And as appropriate for a residential property, based on what I tried to learn, a 200 amp meter is what goes for a residential property, not a 100 amp meter.
Mr. Bagacco has an objection. Ms. Berg, hold on a minute, please.
Is this a question or is this more testimony?
I believe it's testimony, but you can get to a question if you have one, Ms. Berg.
I'm questioning Mr. Sidler's, I believe he said that the meter on the right is a 100 and the meter on the left is a 200. And I believe that to be inaccurate because I opened up the boxes and the meter.
Okay, so Ms. Berg, you have to stop. So the question to Mr. Sidler that you're attempting to ask is, Mr. Sidler, are you sure that of your assessment of which box is 200 amp and which is 100 And how would you know that information?
Okay, well, my estimation, looking at the meters from the front, that the meter on the left serves the residence, and the meter on the right serves the studio.
I believe that is inaccurate.
And if you look at the drawing that Positive Solar put on the back of the,
Let's bring that up. Let's do that, because since this bird probably can't, let's just do it ourselves. I'll share.
Here, examiner, I don't know if that's relevant, which is 100, which is 200, and that's the only reason I'm bringing this up, is because I believe that the meter on the right is the 200 amp meter and the meter on the left is the 100 amp meter. And as you can see, that old dial that goes around.
Okay, you asked a question, Ms. Berg, and we're going to allow the witness to ask the question instead of having you offering more direct testimony. Mr. Sidler, you were saying something about this picture and it reflects upon your judgment as to which meter is which.
okay, if you look at that, you'll see a blue dashed line.
Yep.
Yes,
That's an underground feed from the solar out to the meter complex. And it showed going into the setup that's closest to the studio, which in this case is the big meter box on the service stands, on the service structure.
is that why you think
At it,
the meter
if
is,
you're looking at it from the front, that's the one on the right. If you're looking at it from the back, it's the one on the left.
and so is that why you're assuming that the meter, because of that, just one, that little pencil drawing is what it is? You believe that the meter on the right is the 100 amp meter and the meter on the left is the 200 amp meter? Because I believe the one on the right.
You don't get to state your test. Well, you can say, well, you can just question Mr. Sidler. So Mr. Sidler, going back to the draw, I think it'd be useful to pull this up. So then connect your belief to this picture now.
Mr. Sidler, is this significant, whether which one is 200 and which one is 100 in reaching a resolution for this case? And the reason I ask that is because on P&M's settlement agreement, they wanted us to get rid of the 200 amp.
Yeah, and Mr. Bagacco, you have an objection?
I heard a question at the beginning and then we strayed away from it. If we can at least give Mr. Sidler a chance to answer the question.
Yeah.
The commentary attached to it, I believe he can furnish an answer to that. In regards to the complainant referencing, I don't know, settlement negotiations or other things that I don't necessarily think have been made public in this case, I'm not sure that's appropriate. That's my objection.
Yeah. Ms. Berg,
I don't know if this is significant. I'm just asking, is it significant to recognize that the meter on the right is a 200 amp meter and the meter on the left, in my belief, when I open the box, it says.
Okay, Ms. Berg, you have to ask questions. These aren't questions. You're making arguments. It's absurd. Mr. Sidler, do you believe it's relevant? Ms. Berg, stop. Mr. Sidler, you can answer her question however you feel best. Is it relevant to this proceeding to know which is which?
Yes.
No, it's not necessarily relevant.
Okay, thank you, Mr. Sidler. Ms. Berg, do you have another question?
Yes, one more, please. Mr. Sidler, do you believe that if you buy a residential lot in a residential neighborhood to build a residential house, that it would be exercising sound judgment to put your utilities in first before building a structure and then jackhammering the floors and ripping out the walls? Do you believe the utilities should go in first before you build your structure?
Not necessarily.
So you believe that the floors should be jackhammered up to put the plumbing in, and the beautiful plaster walls should be sawed up before you put the
Yeah,
electricity
I understand,
in.
Mr. Legato. So, okay, you can answer the question, and what she's asking for you is, why do you believe what you believe?
You can stub out the pipe work necessary from the walls and from under the floor and attach to them later without tearing the house up. I mean, you don't have to have the pieces in place. You don't have to have any external panels in place. You don't have to have the conduit runs. You can build the structure, install the system, and provide a means to get to it from outside the structure while you're building the structure.
So you would expect a homeowner to do blasting and trenching after the structure is put up, which could potentially cause damage.
Mr. Legato, what's your objection?
And we're going outside the scope of redirect on this one, I believe.
I believe we are, actually. I didn't get into any of the questions about the appropriate mechanism for building the house and what steps and sequences. The basic question you wanted to ask Ms. Berg has been asked. Mr. Sidler just provided an answer. I think anyone can infer what he's going to say in response to your next step is that it's based on factual predicate that isn't necessarily true. Is that all your questions, Ms. Berg?
I just have one final question is, it has been stated by P&M and you, Mr. Sidler, that we applied for electricity just for our well. We applied for electricity to serve our.
You're testifying, Ms. Berg.
Why do you believe that we would apply for electricity for our well when we applied for electricity to live in our home and have water?
To the extent to which you understand the question, Mr. Sidler, I think you see what she's trying to do. Just answer however you see fit.
Well, I agree you applied for electricity from the well. That doesn't necessarily mean in my belief that you applied for electricity for everything at one point. You can apply for electricity at various stages. I didn't see your application. I'm not familiar with the applications for service. I'm not sure, I'm not sure what the electrical contractor did or didn't do. But
if a customer applies for electricity and it says residential on all documents, why is P&M allowed to claim that we only applied for electricity for our well when that in fact is false? We applied for electricity.
Mr. Hearing Examiner, I'll object. I do believe that misstates P&M's questions and testimony in this case.
We're going to move on, Ms. Berg. This is the same pattern over and over and over. The questions lead with facts that don't exist. I'm going to cut off your ability to continue on with this. Redirect.
Documents, Mr. Hearing Examiner. I sent them to you.
I'm familiar with the documents, but you then misrepresent what the documents actually say in your factual question. So that's not permissible.
I'm misrepresenting the residential.
Yes, it is. It says well. Anyway, any event, let's go to P&M. Ms. Padilla, what questions do you have for Mr. Sidler?
Mr. Sidler, do you recall the hearing examiner asking you some questions about your testimony regarding a possible solution to the complainant's issues of having two separate meters?
Yes, I do.
Okay. And did you hear Mr. Jarrett's testimony yesterday when he talked about this subject briefly?
I did hear Mr. Jarrett's testimony.
Let me just share, if I could, so we're clear on this. The question that he referred to yesterday, Mr. Jarrett, when he talked about well, let me just back up. He talked about a possible limitation of that solution. Do you recall he cited P&M Rule 2, paragraph A7? And I can bring that up if you don't recall exactly.
If you would bring it up, I'd appreciate
I'll bring it up. Yeah, let's see. Okay. Oops, and I'm not bringing up the right document. Sorry. Thought I would have gotten better at this. Okay. Well, oh, here it is. There it is, the PDF. It's the PDF. Walk through this. Why? All right. All right. Are you seeing P&M's responses to the July 13th bench request order?
Yes, I am.
Okay. Yesterday, Mr. Jarrett referred to this question. He stated a possible limitation of the staff's proposed solution is P&M Rule 2 at paragraph A7. You stated already that you remembered that, correct, Mr. Sidler?
Mm-hmm. Yes, I do.
And the rule states, where I'm highlighting here, where premises are used and occupied by a customer as a commercial establishment and also a residence, all service supplied will be billed under the applicable commercial schedule. Do you recall Mr. Jarrett explaining that yesterday?
Yes.
He also stated he wasn't sure, though, whether there might be some latitude in that, depending on a customer's particular situation. Do you remember him using that term?
I remember him saying that.
Okay. So would you agree that this rule may apply in this case, where premises are used both by the customer as a commercial and as a residence? The default rule would be that the service would be supplied under the commercial schedule.
Well, I guess it would depend on, the whole thing would depend on what's considered a significant commercial establishment versus what isn't.
Okay. And
that's a legal determination I'm not able to make. But I'm sure the P&M has a lot of customers that build stuff in their garages and take them to yard sales. Now, P&M does not run out and change their services to commercial rates for stuff like that. I mean, my understanding of what would be a commercial use in this case would be a storefront.
Okay.
He was baking to supply commercial, if she was baking to supply commercial bakeries or commercial stores, perhaps that would make it rise to a level of a commercial establishment.
Okay.
But in this case, and unfortunately, through most of the duration of this case that I've been involved, Ms. Berg's endeavors have been pretty much wiped out by the pandemic.
Right.
I don't believe that she's doing anything right now.
Right.
Because of pandemic. So to sit here and look right now, if she combines those meters, that makes it a residential complex, and it should be served as residential rates. Now, if sometime in the future she starts doing the same thing or puts a storefront in, that would have to be reconsidered.
And actually, to that same point, Mr. Baldwin's testimony, he actually testified sort of similar to what you were saying, that it's his understanding that Ms. Berg is not using the garage studio kitchen for business purposes at the moment. So he said, I believe it would be, it did seem correct in his view that the entire compound could be billed at residential rate 1A.
And I remember Mr. Baldwin saying that as well.
Yep. All right. And that's all I wanted to ask. Thank you.
Mr. Bogacko, anything?
Yes, sir, I do have a little bit.
Sure.
Mr. Sidler, regarding your analyses and recommendations in this case, when you make those recommendations, are you following the applicable rates as written?
Yes, I am. Rate 1A defines use for residential units are essentially dwellings. Rate 2A is everything else pretty much.
And the words that are used in those rates have specific meanings to your mind, do they not, Mr. Sidler?
Yes, they do.
So has it been your purpose in this case to properly realize and apply those rates to the facts that you've gleaned from this proceeding?
Yes, it has been.
And is it also your purpose and intent not to do violence to those rates by fudging, so to speak, on the facts in favor of any specific outcome?
Yes, I've been attempted to live up to those rates and not cause changes to them based on facts in the case, based on the situations.
So honoring those rates based on the facts that have been adduced in this case, is that the proper way to do it?
Yes, it is.
And as you've indicated elsewhere in this proceeding, it's your understanding and recommendation that if the service points were to be combined, that the complainants would likely be entitled to application of the residential 1A rate to their subsequent setup. Is that correct?
Yes.
Now, I think I just heard you say that it's your understanding that the complainants are no longer operating a business out of the studio. Is that correct?
That's correct.
However, before that, and judging by the things you filed in this case, can I take it as correct that Ms. Berg's baking activities really were not pivotal to your analysis? Is that correct?
That's correct. I did not base any of my analysis on what was happening in the building. My analysis was structure type only.
And why is that, Mr. Sidler?
Because that's what counts.
And is it correct that you did not view Ms. Berg's baking activities as rising to the level of commercial activities such that that should figure in your analysis?
That's correct.
There was some discussion earlier in cross about testimony and other things in the record referable to the complainant's reliance on Don's Electric. Do you recall that, Mr. Sidler?
Yes, I do.
And do you recall whether or not we have any documentation regarding what may or may not have transpired between the complainants and Don's Electric?
We have no documentation.
However, is it correct that we do have evidence in this case where the complainants affirmatively indicate that they relied on Don's Electric?
I believe there's been plenty of indications of that.
And when I speak of relying on Don's Electric, is it your understanding that that is in the context of everything that happened to establish the complainant's electrical system on their side of the service points?
Yes.
And do you recall the recommendations you repeatedly made in this case is, as we just discussed, a combination of the two service points. Is that correct?
Can you repeat that?
Yes, do you recall that one of your recommendations is combination of the 2 service points to qualify the complainants for residential 1A rate participation?
Yes.
And we've now been here in this proceeding. We were here all day yesterday and a significant part of the morning now. Have you heard anything in this case that changes that recommendation and for a potential resolution of this case?
No, I haven't.
And briefly, I believe in the scope across, there was some discussion about Mr. Jarrett's and Mr. Baldwin's testimony yesterday in this case. Do you recall that?
Yes.
Mr. Sidler, you were present and you viewed and listened to this case all day yesterday, correct?
Yes.
And that included the times when Mr. Jarrett and Mr. Baldwin testified?
Yes.
Do you agree with Mr. Jarrett's and Mr. Baldwin's testimony?
Yes.
I may almost be done, Mr. Hearing Examiner, if you'll bear with me. And regarding the timeline in this case, Mr. Sidler, if I recall correctly, you still had a couple of issues concerning the exact timeline in this case. Is that correct?
I believe there were some issues. However, the timeline didn't really affect my analysis.
So your analysis is dependent on what you've been able to observe and glean from this case since the date that this formal complaint was filed in 2019 and up to and including your site visit that took place on or about July 17th, 2020 and afterwards. Is that correct?
Yes.
All right. Well, thank you for that, Mr. Sidler. Mr. Hearing Examiner, that's all I have for redirect of Mr. Sidler. I would pass the witness.
Very good. Well, that brings Mr. Sidler's participation here to a close. I believe that's the full submission of evidence in this case. The rules would specify now that we are to have rebuttal testimony by complainants, but I don't believe that. I have concerns that complainants don't provide rebuttal or won't provide rebuttal testimony, but intend to provide direct testimony. So I'm just going to ask the question. Ms. Berg, do you have rebuttal testimony as that is defined within the Commission's procedural rules? Is she muted?
No, I'm here.
Okay.
I did have some questions that I wanted to ask you, Mr. Hearing Examiner, when you asked me yesterday about what I considered to be a trained member of P&M staff. You asked me to describe that, and I believe that I can describe that better today if you will allow me to do that for a moment.
No, we've now concluded the portion of if you have arguments based upon what you believe a qualified staff member is, you will have opportunity to supply that in briefing, which is yet to come. This proceeding is not over in the sense that we are now going to move to some judgment. The next step in these proceedings, Ms. Berg, and this is just so you're aware, is that we close the evidentiary record, and then the parties have an opportunity to brief the issues they believe should be briefed. Legal briefs are documents in which you take the facts elicited at this hearing and apply them to the law that is applicable here and make arguments about what is the outcome that should be reached based on what we heard. So that's where we are. The questions I believe you're referring to regarding what constitutes a qualified employee for the customer service within the P&M's internal complaint procedures, or whatever those exact words are in the rule, that's all legal argumentation. You're entitled to make those claims there. They're not really questions, those are just arguments. So
I can have an opportunity to speak.
Make arguments.
Make arguments.
You have the opportunity to make an argument based on the facts, and if you believe that something about the qualified personnel that you think you need to say, then that's where you'll say it.
Okay, thank you.
All right, so with that, then the evidentiary record in this case is closed. You know, I was thinking about the next step in this. Obviously, we just talked about with Ms. Berg, the briefing schedule. You know, my view is the order identifying and narrowing the issues really sort of tees this up. We've heard a lot today that resolves much of, actually not all the claims, but several. And I don't need to talk right now. I mean, for Mr. Bogacco or Ms. Padilla, I don't know if you want to try to work out right now what are the issues to be briefed. I mean, I have thoughts. We can talk about them now, or we don't have to. I don't know if you all have a preference.
Mr. Hearing Examiner, I believe your order identifying issues which accompanied the third bench requests correctly and properly narrowed the scope of issues into this case. And I think it puts us in the position of getting down to the nitty-gritty, so to speak. And I believe resolution of those questions would be outcome determinative in this case. And that's what I intend to focus on in my briefing. I think we finally have a central set of issues, clarification of the claims, and that's how I envision proceeding with this case towards a final resolution.
Ms. Padilla?
Yeah, P&M largely agrees with what Mr. Bogacco explained, and for Ms. Berg's benefit, these are the issues that are listed on pages 2 and 3 of your order, identifying and narrowing issues for the hearing and the third set of bench requests.
Yep.
So P&M is prepared to brief those questions, Mr. Hearing Examiner, but would also then, I guess, ask whether you have additional issues that, as a result of the hearing in this matter, that you believe you would, you would appreciate legal briefing on.
Yeah, I mean, for me, it seems like the sort of question about the propriety, and this is more me trying to anticipate what I believe the commissioners will want to know. And you don't need to write this down. I mean, just sort of think about it, right? Like the application of rate 2A to the well, and then the decision. Well, it's not the decision. It's the initial application of the rate 2A to the well, and then the continuation of that charging at that rate in light of complainant's failure to ever notify P&M that they want to change. What do we do with that? And I think you could answer that in a lot of ways, but to me, that seems like that's the obvious question. Like, how did these people ever end up with 2A? And then why are they still being billed this way? And I think you all can take the facts and present arguments, right? To me, that seems the obvious question. We've talked about it. I mean, the 2 meters, I think there's answers to all of that. Most of the stuff, I think there are answers. Mr. Baldwin's responses to why he didn't affirmatively advise about the informal or formal complaint. Well, we heard his facts for that. We've heard from Mr. Jimenez, and we know what the record says about his informing them of that. But to me, I think on some level, that's the only real question I have is like, was it appropriate to have the well be 2A? And then, I mean, your point, Ms. Padilla, in pointing out that there's that the reg that talks about if there appears to be a blended use, how do you treat it? Like, that's really interesting. And I think you could probably make lots of factual arguments. I don't think that's like one of these matters where it's cut in stone, like, oh, this is the way it always must be every single time. There's probably flexibility. And what do these unique facts dictate is the appropriate outcome? Does that make sense?
Yes, sir. Mr. Hearing Examiner, will you include that special issue in your subsequent order for a briefing?
Yeah, I can do that. That's fine. And I'll put that down. I mean, I'm just sort of shooting off the cuff here, so I'm just sort of talking out loud. But as long as you guys, I mean, do you agree with me that that's at least something worth writing about in the briefing that'll come?
Yes, sir.
We do as well.
Good. And actually, I think it's very interesting because at the end of the day, I think there's probably lots of answers to this, and in fact, it's just the best. It's like what makes most sense here. So that's my feeling. Okay, Ms. Berg. So what's going to happen now is what was just we're doing is basically the order identifying narrowing the issues sort of sets out what I believe to be really the crux of this case. There are many of your claims that you've issued in this case. For instance, the commission has no authority to put PNM or any of its representatives in prison. That's not going to happen. The commission does not have the authority to issue you damages. That's not going to happen. The matter of informed consent, I've responded to that in some length and pointed out to you what is the law on that subject. And that is also something that's not going to be meaningfully treated, except that I could include the writing already written in the motion to recuse, the response to the motion to recuse, and reiterate what was said there. So those issues that I've identified in the order of narrowing the issues for hearing are really what's at issue in this case. And then the discussion I just had about whether your well was appropriately built from the beginning, and then was there any reason for that to be changed at any time? Did PNM have any responsibility to do that is really the big issue that I see as far as an outstanding question to be answered. So that's where we are. That's going to be the briefing thing. I told Mr. Bagacco I would write that down, and I will crystallize my thoughts more effectively and put it into a paper form. And then the parties will submit briefing. As far as the schedule is concerned, I mean, I would assume we can just wait until the transcript comes out, and then, you know, the initial brief is a 13-day, and then the response will come 13 days later. Is that an acceptable amount of time for everyone?
Mr. Herring, again, for Ms. Berg's benefit, we may just want to clarify that the briefs we're referring to are written documents that the parties file, you know, containing our legal arguments, applying the law to the facts of this case.
Correct. And so, yeah, thank you, Ms. Padilla. I mean, I'll be more explicit. So, Ms. Berg, what's going to happen now is our court reporter, Ms. Tejas, is going to create a formal written transcript of everything that was said in this case. That formal written transcript will also include all of the exhibits admitted in this case. And effectively, that becomes the hearing transcript. That is the official statement of all that transpired here. Then you are free to use that written document to then make arguments applying the facts to the law and are arguing what should be the result here. And you've stated in many different places in all the filings in your case what you think should happen. But the next set of documents you issue are legal arguments that have very little to do with what you feel and believe, and are actually related to what does the law expect and require, and what does that mean in this case, given the facts we've heard. So if that's too much, I don't know how else to tell you what to do.
So I have to file papers after all of this is over on what I think? Is that what you're telling me to do?
I'm not telling you to do anything. What I'm telling you is what the commission's rules dictate. And they indicate that you have the right to file a brief following, well, actually briefs, plural, of initial and a response and reply, I suppose, but like, why would we do that? So you have the right to file those briefs. If you don't wish to do so, you don't have to. If you wish to do so, you do. I can assure you that what will not be helpful to me is to further state what you believe. I have read what you believe many, many, many times. I know what you believe. I'm aware of your view of the facts. I would just want legal argumentation. To the extent to which you think you can do that, you're more than welcome to submit it. If you don't think you're up for that or don't have the energy for it, you are not required to. So, but in terms of the schedule itself, I mean, we can get the official transcript. I mean, I assume, Ms. Padilla, like a lot of your work, you know, you just go back to the motion to dismiss and sort of continue on. So I'm not sure that it'll be a ton of work, right? 13 days is a pretty good amount of time.
I don't anticipate, I think the default amount of time that's stipulated in the commission rules is acceptable to PNM. We could possibly, you know, I don't think I'll truncate at that point without looking at my calendar and seeing if I have any conflicts. So we would, yes, the normal deadlines would be acceptable to PNM.
Mr. Bagacco, you feel the same?
That's fine with staff. Thank you, Mr. Hearing Examiner.
Yeah, that's, I mean, you know, we're not on any big deadlines here or anything. So Ms. Sayers, you have whatever time you need to create the official transcript. I'm aware that I have to supply the commission exhibits. I had not done that. I've not done that yet. I mean, everyone's familiar with the documents. They've seen them on eDocket, but they need to be formalized and admitted into the record. I was going to do that yesterday evening after the hearing. but I was just exhausted and it was a long day. So I didn't get a chance to do that, but I will admit the commission exhibits into the Dropbox account. And then basically that transfer link should still be active. So you all, to the extent to which you wish to have all those commission exhibits, you can just go back in there and download that stuff again. I don't think you can pick what you want to download. You just have to download it again and just drag over the commission exhibits and put those in the file you had previously where you downloaded the rest of the commission, the rest of the parties exhibits. Any questions about the Dropbox? Does that make sense?
No, sir. The Dropbox link, though, shall remain active, I take it, for at least a month or so?
It actually goes in 7 days, so it's a little shorter than a month. If need be, you can always just email me and I can resend it to you. It's not a big deal. But I'll upload the commission exhibits tonight or this afternoon, and whoever wishes to download them, they can do so. And if there's any problems, you can just email me and I will then send you another link for the download. So they'll be kept in perpetuity on my end. It won't be a problem supplying them to you.
Thank you.
Mr. Hearing Examiner,
Yes.
this brief, do I send that to the reply all box?
Yeah, so Ms. Berg, the process is Ms. Tellez is going to create, I told you earlier, an official transcript. She obviously needs time to do that. There's no deadline in this case, so Ms. Tellez is under no big, I believe it's 10 days, Ms. Tellez, that you guys supply those? Yeah, so 10 days from now, she'll supply an official transcript. And then 13 days from that point, once you receive the official transcript, you are then going to be obligated to file your initial brief, as will the other parties. And then 13 days after that submission, you get the opportunity to submit a response. And again, Ms. Berg, just for your benefit, what we're looking for is not further statements of what you think, what you believe, what you feel. It is only your arguments based on the facts presented in this hearing as to what the outcome in this case should be. Is that clear enough, Ms. Berg?
And I get once I type that up, I add an attachment and hit reply all. Because I don't know anything about this Dropbox. I don't know what it is, and I can't take it. I
understand. That's not my, technology is technology, so that's what we're doing. So yeah, you would submit your brief. That's fine, Ms. Berg. You'll have access on eDocket to the hearing transcript once that's produced by the court reporter. You'll have 13 days from the time of the official transcript to submit initial brief, and the 13 days from the initial briefs to file a response. And I will make clear what I believe the most essential questions are. But you already have a precursor to that in the order narrowing the issues. I won't say anything more on the subject. This proceeding, unless there's anything else from the parties, is going to close. Anything further from anyone?
Nothing further, Mr. Hearing Examiner. Thank you.
Ms. Padilla?
Nothing from PNM. Thank you very much, everybody.
Ms. Berg, you're raising your hand.
Yes, I'm sorry, Mr. Hearing Examiner. I just wanted the lady that's doing the typing to, thank her for one thing, or whatever she's doing, Kendra. And I didn't know if this is significant or not, but at the end of the day yesterday, Mr. Hearing Examiner, you implied that when I asked you if I could have a ending testimony or an opening testimony, you said that this isn't like TV and that's not how these things operate. And that was upsetting to me because I don't watch court TV, I don't watch crime TV, I don't watch investigation TV. I don't have time for that. I don't have an interest in that. And I don't need nightmares before I go to bed watching those kinds of disturbing conflicts. And so I want the nice lady that's doing the typing to know that that is not why I filed my formal or my complaint period with the PRC. It wasn't because I wanted to engage in that horrible activity on TV.
Off track.
That's not why I'm here.
You're permitted to write this in some length in whatever format you wish. It's not germane to the issues we're addressing here today. So I'll bring the proceedings to a close. Ms. Tejas, thank you for your efforts. We're going to go off the record now. And I will see you all on e-docket, I suppose.